Okay, let's throw it open for questions now. We got the microphone back there somewhere. Okay, Sarah, and somebody right here in the middle of us. See, two people.
Can you hear me? Oh, I guess I have a question for Fidelma. I've never heard of this public nuisance strategy before, but in a bigger picture, if you think of the environmental litigation and statutes and cases and tobacco litigation, and some communities, including Chicago, I've heard have done had cases involving gun manufacturers. And I just wondered if you see this public nuisance litigation as part of a trend where governments are more and more willing to try new theories to try to address these social, what they see as social problems, or is this just is public nuisance just an isolated kind of theory that you're working on?
I think that public nuisance has not only in the context that you mentioned, the tobacco cases and environmental cases. I think that in the last 25 to 30 years, there's been an increase in a government entity's desire to use public nuisance. I think that what ends up happening in these cases is there's a desire to protect the public from an environmental pollution. And I think that everyone here would agree that, if someone comes in and surreptitiously dumps toxic waste throughout neighborhoods that's poisoning children, I don't think there's too many people that would have a problem with a government entity coming in and trying to protect. And so I think that this is a way of using the legal system to do what governments are supposed to do, which is protect large groups of people, and especially when you're looking at children. Now, what's interesting, I think, about the lead case as opposed to some of the other cases is even though lead pigment was manufactured and sold as a product, it's really much more akin to an environmental type action. And lots of environmental type actions have their basis in public nuisance cases. For example, CERCLA issues, some state resources cases, all came from our codification, partial codification of traditional public nuisance law. And I think that in that way, the lead cases differ from the gun cases. And the nuisance in gun cases is something substantially different than an environmental health threat. But certainly governments have been more willing to use or to look at the potential of using those cases. There's also some cases about dealing with genetically engineered and genetically modified produce that are out there and things like that. The government entities have looked at these public nuisance suits.
Any response from the panel?
I think the public nuisance issue originated in the products context, I think in the tobacco cases. It was pled in a number of the tobacco cases, but I don't think any of those cases were really reviewed before the tobacco settled. It got some traction in the gun cases. Most of the appellate courts rejected it. There were a couple of cases where it went forward. But the big difference, even if you were to accept that you could apply public nuisance in a product liability context, one of the big differences in those cases is at least the manufacturers had some control over what was going on. The gun manufacturers could quit selling guns, tobacco manufacturers could quit selling the product or sell it differently. The really weird part of the lead pigment cases is this is a product that was manufactured 50 to 100 years ago. None of the defendants have been anywhere near the product for probably 30 or 40 years ago and have no control whatsoever in what happens with the product now. But then somehow in Rhode Island, public nuisance went forward. I think that's the big difference.
Who's got the mic? I
have a question for the panelists. I am struck by the similarity in this discussion with the retrofitting of automobiles in California. I was involved in that 30-some, 40-some years ago when the vehicle manufacturers whose cars were emitting oxides of nitrogen, NOx, there was a requirement in California for consumers to install NOx devices on their cars, and contemporaneous with that was the orders to General Motors and the Big Three to begin developing cars with these devices internally on the vehicles. And that's the system that was employed in California, and I'm thinking to myself that had these, or had the Fidelma's theory been applied at the time, the action would have been against the Big Three to spend the money to retrofit 30 million cars rather than the consumers who were driving the cars. And it seems analogous, and I guess I'm asking in Rhode Island, why not just require the folks to abate their house? Why was it the paint folks that are required to do this in Rhode Island, much like the consumers in California who were ordered by our government to retrofit their cars? It never dawned, I think, on the regulators that I worked with that you could go to the manufacturer and say, you guys got to do it. I pose that to the three of you to compare that.
Well, let me make a comment. I think you're right. You know, Rhode Island law, Rhode Island law requires that right now. It's not being enforced. Now, the last time I read the definition of Attorney General, Chief Law Enforcement Officer of the state. I think the Attorney General should do that. That's what the Attorney General should do, or the Attorney General's Contingency Fee Council, if that's the way they continue to organize it.
I need to respond to that because I've let that be thrown out here. There is, inherent in your theory, there is some responsibility that's on landlords, much like there is some responsibility on those who own the cars. We agree with that, and that's always been our position. And I think what is so strikingly different about what the state's position is versus what the defendant's position is the defendants are saying it's all them, we've got nothing to do with it, and what the state is saying is we've got something to do with it. Homeowners certainly have something to do with it, and these companies do too. In Rhode Island and in most places, what has happened through legislation is that there's a couple different ways that you can quote unquote abate. One of them is called interim measures, what you have to do on a regular basis to deal with toxic lead paint in your home. And they're called short-term measures. They don't work for very long. You can do them, and a month later, a week later, 6 months later, a year later, you've once again, there's lead hazards in the particular home, because once lead paint starts to deteriorate, it's very hard. You can't really stop the process. It's just going to keep going. And so there's a recognition that that's something that homeowners have to do in the short term. But the problem with lead-based paint in homes is there has to also be a much more permanent long-term solution, and it's very costly. And it's very, very costly for homeowners who haven't made the decision to put lead-based paint in their home, who had no control over the fact that lead-based paint is in their home now, and who have to deal with some of the responsibility for dealing with it. So I think that, going back to your question, I don't think it's a question of either the companies or a homeowner. I think it's something that, when we're talking about shared responsibility, that everyone needs to be part of the solution.
Well, let me respond to that, because it is the bait and switch that the plaintiff's counsel used with the jury. The jury argument was the Attorney General has done a part of this, the homeowners have done a part of this, the manufacturers just need to do some of this. Just step up to the table, kind of like the last chart that Fidelma put up there. Now, interestingly, a year and a half later, we have the state's abatement plan that has been presented, that the state itself estimates will be $2.4 billion. The plan contemplates these three manufacturers abating every single residence that has lead paint in the state of Rhode Island. There isn't word one in the entire plan of what the property owners are going to do or what the state is going to do, other than oversee us abating every single property. So it all sounds good when it's put in the terms of this is kind of a reasonable approach, but when it plays out, it is anything but reasonable.
Well, and let me make a comment also. it absolutely ignores other sources of lead. And believe me, that's the problem. And I think everybody knows that. And those people aren't being dealt with at all. Really what should happen is the state of Rhode Island should just stop this right now. I mean, honestly, just stop it and get all of the stakeholders. If you're right that there's a stake involved, get all of the stakeholders. Right now, you've got a case that's severed and stayed against everybody that's really responsible. What are we going to do about that? When's that going to get taken care of?
I have one just final question, exercising my prerogative. How does this relate to the market share liability issues that have gone on, I guess, in Milwaukee? It seems to me that we're dealing with, taking Joe's company, and I don't know what your market share was, but I doubt it was the equivalent of what you're getting hit with under the joint and several liability. I assume that's what you're subject to.
I mean, there's no evidence that we ever sold any paint in Rhode Island.
So how does
We
how does this fit in there?
It's a different theory. What Henry's referring to is that in Wisconsin, the Wisconsin Supreme Court has adopted a risk contribution model for product liability cases that are brought by individual lead-poisoned children. And so under that model, because if you look at this wall, you have no idea whose lead paint it could possibly be. And so what the Supreme Court of Wisconsin has done, much like it did in DES cases and other cases as well, is said that there's a relaxed causation or relaxed proof of causation in a product liability case on behalf of individual lead-poisoned children, and that what a child has to prove is that he or she ingested lead, that he or she was injured by lead, that the defendants manufactured or marketed lead during the time the house was constructed, and that in doing so breached some type of duty, but therefore creating a risk of harm to the public and a risk of harm to a particular individual. Upon proof of that, the burden then shifts to the defendants, who can say, hey, we never manufactured or marketed in the particular location or during the particular period of time that the paint was applied. That was actually the case that Mike and I tried together starting on October 1st, that ended in a defense verdict last week. And that was the first issue, and that defense verdict came down on the issue of causation, whether the child had actually been injured, he's 17 now, had been injured by lead-based paint. But it's a completely different legal theory with a different plaintiff, and again, that would be in monetary damages cases. That's one of those cases you have to get injured first, and then you can get compensated for it, as opposed to preventing the harm.
Mike, quickly, do you have any follow-up on that?
The connection with market share and public nuisance is the first of these cases was filed in November 1987 in Massachusetts. There were a bunch of cases filed at the same time. It was clear they were precedent-setting cases. The first cases all were market share cases. They were unsuccessful for the plaintiffs, and over the 20 years, the theories have morphed, trying to get some traction. The defendants have never paid any money in these cases, and by and large have never settled. When market share didn't work, it moved to concert of action and conspiracy. When concert of action and conspiracy didn't work, we got into the public nuisance. The public nuisance got going for a while, got the most traction in Rhode Island, and then flipped back to an effort to get market share liability. And probably the best decision in the country for the plaintiffs is the Wisconsin case. So now we've got market share. They are all part of an effort to get through to what the plaintiffs view as deeper pockets relative to lead paint, all under different guises and theories, but essentially the same case.
Well, we're out of time. Please join me in thanking the panel for their help.